Welcome to the Immigrate Podcast. My name is Richard Wilner. I'm one of the founding members of the law firm of Wilner and O'Reilly, where we're dedicated solely and exclusively to the practice of immigration law. Personally, I've been practicing U.S. immigration law exclusively since 1999, and I've been board certified by the State Bar of California's Bureau of Legal Specialization for over 2 decades. All I do is immigration law. The purpose of this podcast is to provide you with real information in as simple of English as possible. There's a lot of information out there with the advent of AI, non-lawyers, the internet, etc., and there's a ton of clickbait out there. Whether you hire us or someone else doesn't matter. I'd prefer that it be us, but whomever it is, I want you to be possessed of the information necessary that you can build your future upon. U.S. immigration law is complicated, and it's real. Failure is never part of the plan, and it should never be part of the plan. So here we go. Today we're going to talk about the E-1 and E-2 visa. The E-1 or E-2, I tell people it stands for entrepreneur. It doesn't. But for purposes of our conversation, treat it as entrepreneur. You could be an individual investor, or you could be a company overseas that's trying to establish branches here in the United States. What's key is, whether a company or an individual, you have to be a national of what's called a treaty country. What type of treaties are we talking about? In order to qualify for an E-1 or E-2, the country that you come from has to have a treaty of friendship, commerce, and navigation with the United States, FCN treaties. In the show notes to this podcast, there'll be a link to which countries have these treaties with the U.S., and you'd be surprised. There's a lot that you'd think do, but they don't, and vice versa. So, if you come from a national of a treaty country, you can pursue an E-1 or an E-2. The E-1 visa is a treaty trader. Think of the typical import-export company. When doing an E-1 visa, and by the way, some countries qualify for E-1s but not E-2s, and vice versa. Just because you qualify for one doesn't mean you qualify for the other. Most countries that are on the list qualify for both. In any event. E-1s. E-1, think import-export. Doesn't have to be an import-export company, but you have to be conducting trade between the United States and your home country. So the trade has to be substantial. Substantial in the E-1 context is defined as 50% or greater between here and your home country. So you could be an individual from Israel, for example, or from Canada, establishing a company here in the United States as an individual entrepreneur, either as a company as mentioned here in the United States, or an individual with no company or entity rather here in the United States. If it's an overseas company establishing a branch here in the United States, it's the nationality of the company that dictates eligibility for the visa. For example, if the company is privately held, meaning not publicly traded, the nationality of the shareholders, when totaled up, have to be a majority from the treaty country. Similarly, if your overseas company is publicly traded, the nationality of your company is determined by the stock exchange which it's traded on. If, for example, it's the NASDAQ, that would be a U.S. company, and you would not be qualified for the E-1. The E-2, same thing with nationality requirements. However, E-2 is for investment, not trade. The law says, and we're talking about the Foreign Affairs Manual here, and again, we'll link to that in the show notes. The Foreign Affairs Manual does not define what substantial investment is. Instead, it uses words, not numbers, to suggest what substantial means, and it's a bit complicated. Basically, depending upon the nature of your business will affect whether or not the investment is substantial. If you're starting a plastics factory, for example, a $150,000 investment is not going to be substantial, whereas if you're starting an art gallery, $150,000 may in fact be substantial. When dealing with E-1s and E-2s, you have to show that the employee coming over it fits within certain categories. Those categories are either executive, managerial, or essential, and each one of those categories has specific things that the government adjudicators look to determine whether or not the individual qualifies. One nice thing about the E-1 or E-2, unlike the L-1, which we'll address in future podcasts, is that there's no pre-employment requirement necessary. For example, you could identify someone today that you want to come work for your company here in the United States or to work with you in the United States, and provided that the E-1 or E-2 is already set up, that individual who's never worked for you overseas before can qualify for the E-1 or E-2 visa so long as they're a national of the country that you come from and that country is on the FCN list. Unlike the L-1, which again we'll address in future podcasts, there's a 1-year employment history. So the E-1, very flexible, highly recommended if you qualify and if you're looking to do business here in the United States. I hope you enjoyed today's episode and you found something that I said at least useful. If you'd like more information on the subject matter, please don't hesitate to reach out. You may contact us online at wilneroreilly.com.